Hello, my name is Alana Jocelyn Barres Lopez. I'm a student of Universidad Politécnica Ramos Arizpe. My group is AG 102. Termination, suspension, and rescission. Termination. It is the act by which labor relationships are not extinguished, that is, when the object or cause of the contract comes to an end, with the exception of the one that finds its cause in the physical or mental incapacity of the worker. They do not generate any economic responsibility for the employee. Cause of termination of a contract. The mental concept of the parties, the death of the worker, the completion of the work or expiration of the term or capital invest, the physical or mental capacity of inability manifest of the worker that makes it possible to perform the work. Suspension. It is a temporary interruption of the employment relationship, obligation, and rights ceased to exist after the causes of suspension. The conclusion of the decision in the case of the worker's hiring on the dismodality, the conscientious decision of the worker, temporary disability caused by an accident or illness that does not constitute a work risk, the detention of the worker by a quality if the worker acted in defense of the personal or interest of the employer. He will have the obligation to pay the wages that he had not received. If the crime is intentional, whereas a co-worker was, he will not return to work until his innocence is proven. The arrest of the worker, administrative defense, enforcement measure, the fulfillment of the services, and the performance of the changes mentioned in the Article 5 of the Constitution. If a person has to join the armed forces for reasons such as war, a worker who holds a popularly elected position, the designation of worker as representation before state agencies, waivers of conciliation and arbitration, National Commission of Minimum Wage, National Commission for the Participation of the Workers in the Profits of Companies, and other similarities. The lack of documents required by the laws and regulations necessary for the provision of this advice when it is attributed to the worker, cases where the worker with children who have cancer under the age of 16 and who require care. In the case where the competent authorities declared sanitary contingency. Suspension as a disciplinary measure is that the penalty that is imposed on a person by way of court. In addition, disciplinary measures are considered corrective measures that immediately and in order to maintain order and demand that duty, respect, and care be observed in work activities may be imposed by the immediately hierarchically superior of the worker, increasing violation of internal regulation of the worker. Requirements to apply this suspension as a disciplinary measure. There must be an internal regulation. The regulation must be deposited in the conciliation and arbitration board. Workers must be aware of the regulations. Suspension should be not exceed 8 days. Rescission. It is the act by which one of our unilaterally terminates the employment relationship involving serious cause of non-compliance with the other. This means that one of the parties to the employment relationship fails to comply with one or more of obligations set forth. From that moment on, the right of a third party is born to terminate the labor relationship with the offering party without any liability cause attributable to the employer. This cause have the union in the misconduct of the employer when he does not comply with his fundamental obligation to the worker and exercise of the facultative powers guaranteed by law, terminates the employer relationship without any responsibility. Disable the worker in a job proposal, including the employer and his relatives or any other representatives within the services in the lack of probity or honesty, acts of violence, threats, insults, harassment, or social harassment, ill treatment, or other analogous against the worker, spouse, parents, children, or siblings, including the employer, his family members, or workers outside the service. In the facts, refer the previous section. If they are serious, they make it impossible to comply with the employee relationship. This employer salary to that of the worker, failure to receive the corresponding salary at agreed or customary place or date, suffer damage caused or malicious by the employer in his tool or work supplies, the existence of a serious danger to the safety or health the worker or his family, compromise the employer with his reckless or inexcusably careless, the security of establishment or of the people who are in it. Record the performance of acts behavior or behavior that undermine or attempt against the worker, cause attributed to the worker. Deceive the employer with false certification or references in which the capacity, aptitudes, or faculty that the worker lacks are attributed to the worker, including the worker during his work in lack or probably or honesty in acts of violence, threats, insult, or misstatement against the employer, his labor, or the manager, or misses staff of the company or establishment unless they are provocation or act in self-defense. Commitment of the worker against one of his colleagues, such as those in point 2. Commitment of the worker outside the services against the employer, their relatives or managers or administrative personnel, such as those in point 2. Cause the worker intentionally material damage during the performance of work or because of it in buildings, works, machinery, instruments, raw material, and others objects related to the work, quite serious acts of its type without intent but with negligence. Compromise the worker due to his imprudence or inexcusable carelessness, the safety of establishment or of the people who are in it. The worker can be immoral acts or acts of harassment or sexual harassment against any person in the establishment or workplace, revealing the worker manufacturing secrets or disclosing matters of reserve natural to the detriment of the company. Having the worker more than 3 absences in a period of 30 days without permission from the employer or without just cause. The worker disobeys the employer or his representative without just cause as long as it is a contract work. Refusal with the worker to adopt preventive measures or to follow the procedures indicated to avoid accident or illness. The worker attests his work in a state of intoxication or under the influence of any narcotic or any enervating drug, unless in the latter case there is a medical prescription. The defendant sentences that impose a prison sentence on the worker that prevents him from complying with the employer relationship. Thanks for your attention.